Welcome to This Week in Education Law School Administrator's Guide, episode number 17. A couple of weeks ago, on October 31st, the Supreme Court heard an oral argument on two cases that challenged university admission policies at Harvard University and University of North Carolina. The plaintiffs in those cases allege that the university admission policies discriminated against Asian American students. The case I introduced this week is about school admission policy in K-12 schools. Recently, an increasing number of K-12 public school districts have changed school admission policies to increase the percentages of Black and Hispanic students enrolled in elite schools in the K-12 public school systems. When school districts change their admission policies, they rarely use the phrase of affirmative action. But are those admission policy changes legal? Do the K-12 school admission policy changes violate the Equal Protection Clause of the 14th Amendment? Let's look at this case. Montgomery County Board of Education has provided middle school magnet programs in the humanities, math, and science for highly capable students for decades. Traditionally, the admission policy began with the parents of the fifth grade students submitting an application for consideration. Next, those student applicants took the cognitive abilities test, which was an in-person written assessment designed to measure students' quantitative, verbal, and nonverbal skills. The cognitive abilities test scores were then reviewed by the school district along with students' state assessment scores, report card grades, and teacher recommendations. The school district then offered the top performing students admission to one of the magnet programs. The magnet programs offer a challenging academic environment which cannot be attained through honors or advanced placement courses in the students' local schools. As a result, the demand for seats in these programs is high. Over the years, the school district grew increasingly concerned that the magnet programs and other academic programming did not align with the racial demographics of the student body in the school district. For example, in the 2013 to 2014 school year, Black and Hispanic students represented nearly half of the school district's student body, yet they account for less than 15% of the magnet school seats. On the contrary, Asian American students represented 14.8% of the student body in the district, yet they occupy nearly half of the seats. To address the concern, in 2013, the school board adopted a strategic planning framework for addressing equity of access to the school district's choice and special academic programs. In 2015, the school board commissioned Metis Associates, Inc. to conduct a comprehensive study of the school district's choice and special academic programs and identify whether those programs aligned with the school district's core value of equity. The Metis report documented significant racial and socioeconomic disparities in the program's enrollment and acceptance rates. It specifically identified Hispanic, Black, limited English proficient, special education, and the students who were eligible to receive free and reduced price meals as underrepresented when compared to district-wide enrollment data. One of the recommendations in the report sparked much controversy. The recommendation was stated as follows: implement modifications to the selection process used for academically competitive programs in the school district, comprising elementary centers for highly gifted students and secondary magnet programs to focus those programs on selecting equitably among those applicants that demonstrate a capacity to thrive in the program that include use of non-cognitive criteria, group-specific norms that benchmark students' performance against school peers with comparable backgrounds, and or a process that offers automatic admissions to the programs for students in the top 5 to 10% of sending elementary or middle schools in the district. Some board members questioned whether a blind and neutral process would be sufficient to produce the equitable results. But parents of Asian American students expressed their opposition to the report's findings, categorizing the recommendation was an attempt to lower the existing rigorous standards required to gain admittance to the magnet programs. On September 12, 2017, then Superintendent Dr. Jack Smith announced that the school district would implement several changes to the magnet admission process. For the first year of implementation, changes were applied to the Down County programs only. Under the newly developed field test, the school district replaced parent-initiated applications with universal screening of all school district fifth graders. Under the new policy, the school district reviewed all fifth grade students' report card grades and standardized test scores, and the school district invited about half of the student body to take the cognitive abilities test. The field test also eliminated teacher recommendation, which had the potential to be infected by racial bias. The school district then compared a student's objective performance to the student's peer group at their local school. It was unclear exactly how the school district implemented peer grouping. After the implementation of the field test, the percentage of Asian American students offered admission in the Down County programs declined, but the field test had only a marginal effect on the rate of admission for Black and Hispanic students. In several meetings held to discuss the field test results, board members expressed frustration and concern that the enrollment appeared largely unchanged for Black and Hispanic students. One board member questioned the slight increase in Black student admissions, while another board member asked whether some form of affirmative action, either socioeconomic or racial, could be implemented. Another school board member commented that the school district was systematically under-educating Black and brown children, underscoring that rhetorical support for progress not matched with effective policies and structures. Parents of Asian American students expressed disappointment for a different reason. At least a dozen Asian American students who scored in the 99th percentile on state assessments and the cognitive abilities test were denied admission to a magnet program despite their impressive academic credentials. This was the admission policy that was originally challenged in court. In March 2020, COVID-19 pandemic came. The school district's Division of Consortia Choice and Application Program Services, which was a 6-person working group that administers the magnet programs and other choice academic offerings, quickly began discussing necessary changes to the middle school magnet admission process. Beginning in the July of 2020, the consortia first tackled the logistical difficulties that the remote learning presented for administering the cognitive abilities test, which could not be given to students remotely without compromising test security or equity of access. The consortia decided to abandon the cognitive abilities test. The consortia, in consultation with the school district's senior leadership, designed and implemented the pandemic plan for magnet middle school admissions in the 2021 to 2022 school year. Under the pandemic plan, the school district universally screens all fifth grade students for placement in an eligibility pool. Any student who received an A in the relevant subjects performed above reading grade level in fourth grade and received a locally normed minimum of 85th percentile on the reading assessment or math assessment is placed in the pool. Next, the school district used a lottery system to choose from the pool the student to be admitted to the program. Amid the COVID-19 pandemic, the school district believed the lottery selection system would reduce selection bias and subjectivity, and was logistically the simplest option given persistent remote work and instructional challenges arising from the pandemic. On September 30, 2021, the school district announced it would implement the pandemic plan for the foreseeable future. As of this time, the school district leadership had changed almost completely. The then superintendent, who was responsible for overseeing the METIS report and the field test, retired, and a new superintendent took his place. Also, the composition of the school board had changed substantially. Only 3 of the 8 members who had participated in the field test controversy remained in office. After the school district announced that it would implement the pandemic plan indefinitely, the Association for Education Fairness amended the complaint by abandoning its challenge of the field test and instead alleging solely that the pandemic plan discriminates against Asian American students in violation of the equal protection of the 14th Amendment. Since both Association for Educational Fairness and the school district agreed that the pandemic plan was a facially race-neutral admission policy, the issue became, first, whether the pandemic plan had a disparate impact on Asian American students, and second, whether the pandemic plan was motivated by discriminatory intent. Let's first look at the question whether the school district's pandemic plan had a disparate impact on Asian American students. To decide whether the pandemic plan had a disparate impact, Association for Education Fairness argued for a simple before and after comparison. But the district court reasoned that the proper method for determining the disparate impact is the percentage of applicants versus the percentage of offers. That is, whether members of one group have proportionately more difficulty securing admission than others. Using this method, under the field test or pandemic plan, Asian American students consistently have occupied a proportionately greater share of students admitted into the magnet program as compared to their representation in the applicant pool. The court concluded that the pandemic plan did not have a disparate impact on Asian American students when the percentage of admitted Asian American students so substantially outpaced the percentage representation among all applicants. Let's move to the second question, whether the new school admission policy was motivated by discriminatory intent. How did the court decide it? The court conducts a sensitive inquiry into the circumstantial and direct evidence of intent. 5 factors were used to guide the sensitive inquiry. First, historical background of the pandemic plan. Second, the specific sequence of events leading to the plan. Third, the pandemic plan's legislative history. Fourth, whether the school district departed or varied from its normal procedures in enacting the plan. And fifth, whether the pandemic plan bears more heavily on one race than another. The first 3 factors were evaluated by the court together. The originally challenged admission policy was the field test. the policy has morphed into a different one due to the change of school board members, superintendent, and the impracticality of administering the in-person cognitive abilities test. The dispute here lies with how much of the past matters. The Association for Education Fairness argued that the court had already concluded that the complaint had plausibly stated an equal protection challenge to the field test. Then the same inferential benefit of the doubt should carry the claim here. However, the school district argued that the court should not give the history of the field test an outsized impact. The court cited the Fourth Circuit's ruling on North Carolina State Conference of the NAACP, Me Raymond, and reasoned that the policy was created and adopted by the consortia under the leadership of a new superintendent. The COVID-19 pandemic made the in-person cognitive test impractical. The school district canceled the test and used a wholly new screening and selection process under the pandemic plan that bears little resemblance to the field test, which was the policy originally challenged in the court. The court concluded that no evidence suggests the consortia intentionally aimed to rebalance the racial composition of the magnet programs. Did the school district made substantive departure from the factors usually considered important in decisions in this kind? The Association for Education Fairness argued that such a departure is apparent given that the field test and the pandemic plan were adopted and implemented in vastly different ways. But the court reasoned that the consortia has always been tasked with evaluating, administering, and altering admission processes for special programs, including the magnet middle school programs. The consortia did what it always does: create a plan, announce the plan, and implement the plan. The court noted that it made little sense to attribute the COVID-19 inspired changes to the magnet program as somehow nefarious. The last factor to determine whether the policy has a discriminatory intent is whether the pandemic plan bears more heavily on one race than another. The court reasoned that Asian American students continue to maintain strong representation in the magnet programs relative to their composition in the applicant pool. The court could not view as plausible that Asian Americans have been systematically excluded from the magnet schools for no apparent reason, given that the final selection for magnet admissions was wholly randomized. It was possible that the disparity was due to chance or other changes to the admission process. The school district's admission policy did not burden Asian American students, let alone that it burdened Asian American students more than any other cohort. In summary, the court concluded that the school district's admission policy did not have disparate impact on Asian American students, nor did it have discriminatory intent. The admission policy in this video is very different from other admission policies that are challenged in courts. In this case, the process of policy development and adoption did not depart from the normal procedures. The original policy has morphed into a completely different policy due to the pandemic. But how to decide whether a policy has a discriminatory intent is still contentious. Some courts used a before and after comparison, but other courts, like the court in this case, use the proportions of applicants and offers. School administrators still need to exercise extreme caution while making efforts to increase racial diversity. I hope the case introduced today is helpful for your daily work. I will see you next week in This Week in Education Law, School Administrator's Guide.